All right, let's talk briefly about Medicare and Medicaid. And if you ignore Medicare or Medicaid, you will wind up in very, very hot water. Here's what I mean. Let me tell you the story of a gentleman who I represented where Medicare destroyed his entire case. Oh, by the way, before I do that, let me touch on damages. What type of damages are available for a medical malpractice victim? Well, just to give you a broad idea, there are economic damages, past lost earnings, future lost earnings. There are medical bills. There are funeral bills if it's a wrongful death matter. Well, what other economic losses are there? How about loss of an opportunity, loss of a job opportunity, loss of a business opportunity? You may be able to get certain insurance company premiums back. Although with Obamacare, I don't know if that'll happen. But in any event, what you do need to know is what damages may be available. And then we have non-economic damages, pain and suffering, past pain and suffering, and future pain and suffering. The suffering for the harms and losses you have suffered into the foreseeable future based upon your expected life expectancy. Very, very important. How about in a wrongful death matter? What type of damages are available? The biggest component is pain and suffering from the time of the wrongdoing until the time the person died. And that could be very short. It could be seconds, it could be minutes, hours, days, or longer. And then we ask, what's the pecuniary loss? What is the financial loss to the family as a result of this person's death? Were they the breadwinner? Were they working? If they were not working, then the entire pecuniary loss claim is gone. Is there a loss of spousal services, known as loss of consortium? Did he have a spouse? Did he have children? Are they adult children? By the way, adult children can recover for loss of a parent, for loss of guidance. So these are just some of the potential damages that can be claimed in a wrongful death matter. Now, let me jump to the Medicare issue. Everybody over the age of 63 or 65, you have to presume is a Medicare beneficiary. If you don't, you're going to be in significant trouble. We, as attorneys, have an affirmative obligation to contact Medicare and raise your hand and say, hey, Medicare, just want to let you know Mrs. Gonzalez here is bringing a lawsuit seeking compensation for the wrong done by the doctor and hospital over here in New York City. And Medicare says, excellent. Now I can go and get paid back all the money that we paid for your medical expenses. And by the way, if you do not do that, and let's say you settle a case and disperse the money, and now Medicare comes knocking at your door, they say, oh, by the way, Mr. Oginski, you owe us $300,000. You say, what are you talking about? I didn't know that Medicare was owed this money. Haha. You have an affirmative obligation to find out if there is a lien. It's your obligation. You fail to do that, you lose. And by the way, Medicare, since they are a federal agency, doesn't have to go to the client to recoup that money. They can come to you. They can go to the defense attorney, the defense firm, the insurance company to get that money. But the first person they're going to come to? Me. I had the affirmative obligation to see whether or not there was a Medicare lien, whether they paid for any of the bills associated with the improper care our clients received. And here's something devastating. They can recover not just the amount that has been owed, 3 times that amount, treble damages. So if you think it's a laughing matter to ignore Medicare, I will tell you right now, it is no laughing matter. There have been some attorneys who have made that mistake, and you don't want to be one of them.